program, to this event where we are which is part of a series of events organized by the Global Policy Institute and Bay Atlantic University, where we try to look at different aspects of what's happening because of the pandemic and coronavirus. But certainly today's topic is not, I guess, directly related to the pandemic, but it kind of can be framed in that context, because I guess in the general context of a huge economic upheaval that we are all, witnessing or experiencing, depending on where we are. And so we are really fortunate to have with us Hal Singer, who is an economist and an expert, really, in understanding the various nuances of markets and the threats to markets, I guess. And in this capacity, he acts as a consultant and an advisor to law firms, to people who are litigating or potentially disputing aspects of markets and access and antitrust and price fixing and whatnot. By the way, let me step back for a moment. My name is Paolo von Schirach, for those of you who don't know me. I serve as the president of the Global Policy Institute, and I'm also chair of political science and international relations at Bay Atlantic University, the academic institution closely affiliated with the Global Policy Institute. Our guest, you've seen his bio online, long and distinguished, but he runs an economic consultancy and outfit, and as the managing director, and as I said, in this capacity, he and his colleagues provide important advisory services to those who need to understand the nuances of the economic significance and the legal implications thereafter, of how basically certain aspects of our economy is run. So I just wanted to, for openers, and since obviously many of us here today are not specialists, are not lawyers, and certainly they're not antitrust lawyers, maybe Hal, you can just give us a flavor without getting into too many specifics of what is it really that we're talking about. We understand antitrust legislation goes back more than a century in the United States. What was it that legislature, the Congress, and the president at that time had in mind? And how has this carried forward more than a century later? Where are we on all this? I guess it's a small question to begin with.
Well, thanks for having me on. And let me try to take that one. So what was the objective? I think that what Congress was intending to do was to curb the power of the big trusts that had come together and formed in the early part of that century. And I think there were two concerns. There was an abuse of economic power, that is, the trusts could raise prices on consumers or restrict output or do other anti-competitive things. But there was also a concern about the abuse of political power, that is, that Congress itself could become captured by powerful firms with strong political interests. So I think those were the dual objectives of the antitrust laws. And they have the enforcement has waxed and waned over various time periods. But at this time period that we find ourselves in during the pandemic, antitrust is at a pretty weak level of enforcement. There's two types of cases that antitrust agencies typically pursue. One are to attack conspiracies. Those would fall under Section 1 of the Sherman Act. That involves two or more firms, of course. Price fixing conspiracy would be your garden variety case. And then
Can you just elaborate on that? Because again, these are practical examples, and there have been several cases. And also, by the way, also internationally, other jurisdictions, other countries have active anti-cartel, I guess, laws. I mean, in layman's terms, what does that mean? Companies getting together to do what? Secretly, yeah. I guess.
Typically, it's to get together to conspire on the prices that they will charge to their customers. There are other types of conspiracies relating to output, for example, or capacity. There are some allegations the airlines have colluded to reduce capacity in the United States, for example. They generally involve price fixing. And the Department of Justice has been fairly aggressive in this vector, although the American Antitrust Institute just put a report out that shows that even on this dimension, enforcement is falling relative to prior episodes of enforcement in U.S. history. So that's one set. Those are the cartels. But I think for our talk today, and when we're going to talk about Amazon in particular, or other dominant tech platforms, we have another section of the Act, Section 2, that gets at monopolization by single firms. This is a firm now acting by itself. And here, the enforcement has really slacked off in the last decades. The very last Section 2 case brought by the Department of Justice, major one anyway, was against Microsoft in the late 1990s. So that gives you an idea about how long it's been since we've had robust enforcement of Section 2 and the monopolization law. So here, just to kind of bring it down to earth, we're talking about any types of restraints of trade that are imposed by a single firm. So some of the common forms that you've probably heard about would be like a tying restraint. So a requirement that I'm not going to sell you what you want from me, product A, unless you also buy a product B from me. Bundling would be in the same category. We used to pursue predatory pricing under Section 2, but we don't any longer. We also used to pursue these monopoly leveraging claims. That is, you would try to leverage your power in one market, into another, and that has largely become a dead letter in antitrust enforcement as well. So those are the two big types.
Let me ask you again. You clearly illustrated that at the very beginning, at the end of the 19th century. So the American love affair with business was very much alive. But say, hey, business is good. But if business gets to be too big, then we're uncomfortable, right? Because it's too big, it's too powerful, and as you said, not just in economic terms, but then trying to exert their leverage because these people who control huge companies, these trusts, get to be so powerful that maybe they buy the government. They exercise undue leverage, and so let's bring them down to earth, and let's do that. At the same time, the idea was that what we want is a lively competition in the market, right? And therefore, if it is too concentrated, well, then there is no competition anymore, right? So this is what the things we've been struggling. That to say we love big business because big business can perhaps then invest more, innovate more, do new things, et cetera. But if it gets to be too big, it's dangerous, right? That's the general sentiment behind all this. Is that correct?
That's right. And so there was a sentiment that there was a problem with bigness per se. And again, but that's the old school of economic thinking or antitrust thinking. That association that bigness is bad is often discussed as kind of the new Brandeisian, named after Judge Brandeis, the Supreme Court. And what we did originally is we used indicators of concentration within an industry or firm size as symbolic of something bad, the exercise of market power. And there was a revolution against that was brought about by Robert Bork and others that are associated with what's called the Chicago School, that said maybe we shouldn't fixate on bigness per se, but we should focus on the acts themselves and only those acts that result in tangible, measurable harms to consumers. And that standard that evolved is known as the Consumer Welfare Standard. And it is largely refined and narrowed the scope of the types of actions that can be pursued under the antitrust laws today. And some would argue that the new Brandeisians, those who are trying to revitalize kind of the old school, that it has shrunk the scope so much that antitrust has effectively become toothless.
Okay, so yes, so again, for all of us to be able to appreciate all this, on the one hand, initially it was said that too big is bad almost by definition, because it brings with itself all kinds of evils. And then a reduced version say, hey, wait a minute, let's see if big causes harm, right? Basically, does it cause harm? Is there a demonstrable relationship between oversized companies and harm to consumers in terms of prices, I guess, in terms of choice, in terms of new products probably coming to the market. So that has, you say that this narrower approach, in a sense, has, if not killed, but somewhat reduced the scope and the ability to get to these cases. That's your contention?
That's right. That's right. So, right.
Okay.
So now what really drives antitrust enforcement, I mean, again, there's not much going on at the agency level with respect to Section 2, these monopolization cases, but at private enforcement, and what I mean by that is brought by individual firms or by collections of buyers in private, like class action enforcement. What really drives that litigation right now are tangible, measurable harms that you could take to a judge or to a jury and say, look, this is what they caused. It was a combination of their size and the restraint that generated these tangible, measurable anti-competitive effects. And these types of conducts or restraints that are associated with those tangible effects are cognizable under antitrust. And there is some enforcement. Again, it's coming mostly from private quarters. The problem, however, is that, and this is something that economists and the new Brandeisian both recognize, that we can have anti-competitive harms, and hopefully maybe this will bring it back to Amazon too. We can have anti-competitive harms that don't manifest as short-run price or output effects. That is, we can sense that something is off, right? That competition is being impaired or damaged, that the playing field is unlevel, for example. But an economist can't measure it, right? And so if the standard is only picking up those acts that generate, tangible price effects or tangible output effects, then we might be missing out on a whole bunch of harms that we recognize as a society, should be restricted, but are currently allowed to occur.
One of the questions I saw coming through on the screen is about, perhaps explaining the difference between horizontal mergers and vertical mergers, and what does that mean? Because again, we've seen cases brought up even by the Department of Justice at both levels with mixed results, it seems. But can you briefly explain to everybody what that means, horizontal versus vertical mergers, and why would what kind of threat either case represents?
Sure. So the word horizontal, you can think of just kind of being on the same playing field, so on the same level of the distribution channel. So an example of a horizontal merger that was just waved through by the Department of Justice, in fact celebrated, was the T-Mobile Sprint merger. That was horizontal in the sense that T-Mobile and Sprint compete directly against each other. They're head-to-head horizontal rivals. And in that case, the states had to bring their own challenges, and they failed. But the Department of Justice was actively lobbying on behalf of the merging parties to get that merger through. In fact, the head of the DOJ antitrust division was calling senators or calling his friends over at the Federal Communications Commission to see how he could kind of work back channels to make that deal go through. So that's a horizontal.
But on that note, why is it that there's this divergence then between the Department of Justice, which has its own antitrust division, and I guess the state attorneys general, that said no. So we are against it. What kind of policy objectives was driving the opposition coming from different quarters? As you said, the Department of Justice approved it, say it's okay with us, which means more concentration in the telecom sector, which is already pretty narrow with a couple of players. Now, what is it, 3 now, basically?
Yes, now 3. That was
AT&T, Verizon,
That's right.
and the merged Sprint T-Mobile. By the way, I'm a T-Mobile customer. I don't know if I'm going to get any goodies out of any of this. Probably not. But so what kind of philosophies or what sort of argument? Because obviously, if the Department of Justice says no, it's okay with us, that means this is going to be good for the economy and good for the consumers, good for innovation. and then the others say, no, 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 this is not good. This will restrict competition, will raise prices. What is, obviously they're looking at the same data, right? Supposedly, but they're drawing completely different conclusions. Why is that?
It's a great question, and I can only kind of fathom an educated guess. But and I don't want to be too harsh on the current DOJ, because their kind of lackadaisical attitude towards enforcement is really not unique. You know, even under Democratic administrations, under the Obama administration, the enforcement was fairly minimal and lax. So there is a concern among those who are kind of observing this this tendency not to enforce of a revolving door between those who work in the agency and then those in the private sector who are kind of seeing these deals through. And the concern is that if you if you were to take too aggressive of a stance at the agency, that might limit your future economic opportunities to put these deals through the agency, once you come out. I mean, I hear that as a possible explanation as to what's going on, with the agencies. Why is the enforcement so lax? I mean, there are less nefarious explanations too, which is that courts have increasingly interpreted the antitrust laws in a very narrow sense, and so the agency heads are just afraid to bring a case at the margin because they don't want to lose. They don't want to have a loss on their record. Go ahead.
Before we go into the more interesting stuff, contemporary things of the big tech, which is really our topic, just again as an effort to frame the issue, so that everybody can see the contours changed. I remember, please correct me if I'm wrong, that already many years ago during the Reagan administration, that there was some kind of a cautionary approach saying, yes, we don't want these big companies to become too big and this and that, but we got to but there is a global competition, right? We American big companies are facing new national giants, right? Especially at that time, Japan was considered the big, bad guy, or at least danger. Now, of course, it's China. But at the time, people said, if we restrain size, for big American companies, that will undermine our global competitiveness, because we cannot enforce the same restraints, or it would be very difficult on foreign competitors, right? And so say, hey, yes, let's worry about getting too big, but consider the changed context. We are now in a global economy, and we want our companies to be big enough and strong enough to compete globally. Is that still, does that make sense? Is that still a sentiment that you can perceive, especially now that globalization is, whatever, maybe now with coronavirus is a different story, but at least prior to coronavirus, it was the religion, so to speak, of everybody.
No, I think that was part of the motivation, but I think that was a small part. But yes, there's a grain of truth to what you're saying in the sense that if we open our borders and we allow foreign companies to compete against our domestic firms, we might be able to take a less aggressive stance towards consolidation among the domestics, under the notion that competition will remain invigorated. I mean, it didn't work out that way. That may have been one of the motivations. But I actually think that the Chicago school movement that I mentioned earlier, it started in the 70s and kind of culminated with the Reagan administration, was really just pushing back on the notion that antitrust was a good thing. They saw it as kind of heavy-handed government intervention that was going to deprive consumers of the benefits that even a monopolist could bring, and they had a notion that markets were contestable. I think this is a fancy way of putting what you just said with respect to foreign competition. Markets are contestable in the sense that even if a market falls subject to a temporary monopoly, that those monopoly margins would invite entry by new firms, potentially foreign firms, so that consumers would always be protected. Yes, I think that was the overarching belief. It didn't turn out that way because I think it turned out that these monopolists were very good at creating moats around their businesses that would protect them from entry. There are also just natural barriers to entry. We talk about some of these network industries that we'll get into, hopefully, like Amazon and the like, or Facebook, but they're subject to what are called network effects, so that when everybody initially joins one platform, it becomes very difficult for a new platform to emerge, because you'd have to coordinate the departure of all of those customers at the same time. You wouldn't be able to survive just by, say, picking off a small portion of them.
Indeed. Yeah, that seems like thank you for that. I mean, that seems like a good moment to move on to the main topic of our conversation today, and this is the big tech companies, which, as I'm sure you can explain that better than I can, I mean, are really different because, the odd thing, you look at Google, well, you would say, hey, their products are free. How can you talk about price gouging or trying to take advantage of consumers, what have you? It's free. Give me a break. What's the problem? Shouldn't we all be happy to have a benevolent giant that gives you all these services for free? Or Facebook, same thing. It's free. I mean, they make money through, as we know, through advertising. But of course, others are not free. I mean, Amazon is not free. Apple is not free. But can you tell us, we've now entered essentially a new era here. And it seems like the tools and the laws that were framed in a different era for different cases, it's hard to adapt them creatively to make them relevant to this new environment. Can you explain to us, what kind of world have we entered, and what are the challenges in terms of trying to maintain free markets in this new era of new technologies?
Right. So you put your finger on the problem, which is that we don't observe price effects by many of these platforms. Even with Amazon, where we do observe prices, Amazon's whole strategy is to have low prices. And so in that sense, Amazon is able to evade antitrust scrutiny under this consumer welfare standard, because if you send in an army of economists and you say, show me the harm and measure it down to the last decimal place, they'll throw their hands up and say, how do I show harm? Google, you mentioned, is a free product in the sense that search is free. It's not free on the advertising side. But the problem, and I'll just give you some examples of the types of competition problems that we care about as economists, but seem incapable of going after, at least using the traditional tools of antitrust. So Google, for example, will decide that it wants to invade a vertical, right? And so there's many famous examples, but one that I like to talk about is local search. And so you had independent content providers like Yelp who had come up with a new offering that rode on top of the Google ecosystem. And so in the old world, Google would used to steer searches to Yelp and other independent providers who had made an industry out of an entire business out of offering the content that was the result of a Google search. And Google figured out that why should we be steering these searches to third-party content providers when we could just steal the content ourselves and make it the Google branded content. So Google entered local search. They didn't just enter local search. They entered shopping. They entered a whole bunch of verticals, right? Now, when Google steers a searcher to its own property, or when Amazon steers a searcher to its own private label, Amazon is operating a fairly similar design or scheme in the sense that it's based on search and a search algorithm that can be distorted in favor of the platform's content or wares, right? Where's the price effect, right? If all they're doing is diverting searches from an independent merchant, right, to the affiliated clone, right? The question is, where's the price effect, right? The prices are not necessarily any higher, and so you send a team of economists in, and they come back with their hands up in the air, right? And we recognize that the problem here isn't that consumers are going to pay higher prices in the short run necessarily. The problem is an innovation harm, what economists call an innovation harm, right? And the innovation harm goes like this. It's that imagine you're a merchant and Amazon has cloned your product and then has manipulated its search algorithm so as to give its own clone preference in search, right? And just basically attacks that vertical and takes it over, right? And you're a merchant and you're watching this happen, vertical by vertical. You might say to yourself, boy, this is really scary that I'm gonna make an investment here only, and if it's a loser, I'm gonna lose money, and if it's successful, Amazon's just gonna steal it, right? And so what would happen, what we worry about is that in future periods, if enough merchants are kind of observing this appropriation, that they might just decide to throw in the towel and not compete, right? And so the harm would be a harm from a reduction of future choices, right? That is caused by this kind of dual combination of appropriation and discrimination by Amazon. So this is an innovation harm, and it's not one that we can measure today, right? And it eludes antitrust scrutiny. Now, antitrust makes reference to innovation harms. You'll see it in certain opinions, but what I've been able to document is that innovation harms are what's this basis. A court stopped conduct that it thought it was anti-competitive in violation of the Sherman Act exclusively because of an innovation harm.
That's a very good point here, and I think this is where it gets important, and I think intuitively all of us can appreciate that, but difficult to measure, right? You said earlier, correct me if I'm wrong, you said, even though, say, Amazon can say, hey, I am only, a little piece of the American, commerce, which is technically true, right? They're not controlling American commerce, and they're not even controlling online commerce. There are many, many other players. But as you indicated earlier, there's this network effect that, you attract more and more people to your platform because you're so big. And then if you can vis-a-vis these giants. And so this barrier to entry issue, I think it's a really potentially a huge concern. We thought, broadly, please correct me if I'm wrong, with the age of the internet, it's this giant free-for-all, right? Everybody can do anything, anybody can compete against anybody, and having a foothold in cyberspace is very cheap and getting cheaper all the time. Platforms are improving, and technology and all that stuff that we know. But it turns out it's not that way, right? It didn't really work that way. And so now we have this emergence of these giants, even though in percentage they may not be the majority holders, so to speak, in terms of market share, but inhibiting participation and innovation. Is that how do we handle this? You mentioned something earlier, but maybe you can elaborate on this.
Yeah. So I think there are two strategies to attack this, right? One is how do you engender more platform competition? So competition for the market. How would you stand up a new social media company to go up against Facebook? That's a tough one, but that's one idea. The second idea, and by the way, these aren't mutually exclusive. You could do both. The second idea is like coming up with certain new protections that either sit outside of antitrust or sit inside of antitrust, but you'd have to reform the antitrust standards, right? That would tolerate these monopolies, but restrict their abilities to inflict certain harms via rules and regulations. These are really the two strategies. But to your point also about barriers, there was a time where even a decade ago, we thought that these platforms might even invade each other's domains. So that Google had talked about, you may recall Google Plus, but it was Google's attempt to invade social media, right? And they've abandoned that. And the question is, if someone like Google, with all the means and resources of Google, can't give Facebook a fight, can anyone? And we see with Amazon, you mentioned that they were small. I just want to push back on that gently. In e-commerce, Amazon likes to cite this statistic. It turns out to be a bogus one, that they only have 40% of all e-commerce sales. And the problem with that statistic is that in the denominator, they're including all commerce that occurs over the internet, products and services, including those markets in which Amazon does not participate, right? And so that has the effect of deflating, artificially deflating their shares. There's a study by an outfit called Jump Shot that looked at what Amazon shares are within the markets that Amazon actually participates, and it comes out to an average around 74%. And in certain markets, they're as high as 90%. These are sub-markets, if you will. Markets, these are electronic commerce markets in which Amazon actually competes. So if someone were thinking about bringing a case against Amazon, and there is a private class action case right now against Amazon with respect to its most favored nation clause, I have no fear that the plaintiffs would prevail on this monopoly power requirement. That is to show that Amazon has monopoly power. That's not what's going to trip them up. Where the rubber meets the road will be whether a plaintiff would ever be able to show that Amazon's conduct resulted in some tangible, measurable harm that is cognizable under the antitrust laws. It's these anti-competitive effects that I think defy measurement and therefore defy antitrust scrutiny. And then if so, what are we going to do about them?
Let's also look at the challenges, I think, of harmonizing or at least reconciling different type of antitrust norms and philosophies that affect, as a minimum, this global giants. Because we know, and there have been some, very sort of headline-grabbing cases. Going back, if I may, to Jack Welch in General Electric, trying to acquire back in, was that in the 80s, Honeywell, and they were completely blindsided by an antitrust action, basically a blockage coming from the European Union. And people say, what's that got to do with anything? These are two American companies, two major giants in the aerospace business, and it would create synergies for General Electric that makes, avionics and the jet engines, and Honeywell does other things. So what's that got to do with anything? And they were told that this would harm competitors, and the deal was killed, essentially, by a rather unknown at that time economics professor from Italy, who happened to be the competition commissioner at that time, Professor Monti, and that was that. And this was supposed to be the crowning moment of Jack Welch's career, right? And it was killed. And now, in more recent years, we've seen activism coming from Mr. Monti's successors in that capacity. This Danish lady who's been extremely active and promoting actions against Microsoft, against Google, and all that, and with having with big fines and punishments and remedial action required. What's going on there? It seems like Europe has especially when it comes to big tech, the primary concern is privacy, right, and respect for what are kind of pieces of an individuality that are kind of pilfered by the data gathering sophisticated technologies of the big giants. Can you explain what this is, and why is that such a big concern? Or it looks like a bigger concern in Europe than here, relatively speaking. But again, the big tech companies have to take notice.
Right. So yes, Europe has been much more aggressive vis-a-vis our dominant tech platforms than we have. And that's a good thing. The problem is that many of these decisions that come down in Europe don't have any bearing on the way that the dominant platforms behave in the United States. Now that may change if the incision or the invasion that Europe imposes is sufficiently significant. It might force a change here. But I can give you a few examples. EU went after Google's preferencing, self-preferencing, we call it. Again, that's this notion that you give yourself preference in search in a case involving Google Shopping. So the Europeans intervened there. Of course, there hasn't been any analog in the United States. And then we also have a famous case in Europe against Amazon involving the most favored nations clause, where Amazon was barred, at least with respect to, I think, booksellers, of requiring booksellers not to offer a lower price outside of the Amazon platform. You know, so that MFN, that most favored nation clause, was blown up in Europe, but it really has no force in the United States because it's still, Amazon still does that here. We understand that some new decisions are imminent in Europe. They're going to issue new opinions and findings with respect to self-preferencing. And you know, I'm hopeful that something good will come out of it. What I'm nervous about is the U.S. relying entirely on Europe to solve its own competition problems. So you know, I've been peddling, and many others have as well, solutions inside and outside of antitrust that would get at, you know, the core of the problem, and how to solve it in an efficient way that would permit the tech platforms to continue doing good things, but to curb their anti-competitive impulses.
But what do you see right now? I mean, again, switching back to the home front, what's the outlook now for the big tech companies? You know, one of the things that has been discussed, obviously, is currently, and I think with some justification, is with this carnage taking place in the economy right now, sadly, on account of the forced shutdown of most firms due to the coronavirus. Once the emergency is lifted, there will be many bodies, right, on the floor, sadly, companies that, just notwithstanding state subsidies and aid and preferential treatment and loans and what have you, just couldn't make it. And that becomes, you know, the hunting ground for the big companies, whether it's the big tech companies or others. I don't know, it could be oil companies, it could be others, right? And that's basically a danger, because, okay, there will be more concentration in the end, because the survivors will eat up whoever is left, either dead on the ground or too weak to survive, and they will be absorbed. And by the way, we witnessed some of that after the financial crisis, right? We were talking about earlier, oh, too big to fail. Oh my God, we don't want to get there. Well, the too big to fail banks have become bigger, right? As a result of the carnage that killed so many small lending institutions at that time. So how do you view this, and what does that, you know, I know it's too early to say, because we're not at the point in which the dust settles. The dust is pretty much, you know, up in the air. How do you view all this, and what are the pitfalls that you see emerging from an environment in which many small players in tech or in different areas will inevitably disappear?
Yeah, so the way this is playing out, I think most forcefully is what's happening to brick and mortar retail outlets. So they were weakly competing against Amazon before the pandemic. And now you could say that they're not competing at all. And so Amazon's scope, or its domain, is going to expand and take over activities that used to occur inside of these brick and mortar in the physical world. And what that's going to do is going to make the brands even more beholden to Amazon, and that'll allow Amazon to exercise even more power vis-a-vis the brands. That is, Amazon will be able to impose, say, higher commissions or other owners' requirements. And it's also another kind of interesting thing is we talk about antitrust in labor markets, but it's also going to make workers more dependent on Amazon as a place of employment. So Amazon could abuse its power vis-a-vis workers by, for example, paying them less. We read that they're already going to suspend this $2 per hour premium that they were paying for hazard pay, and that's now going to be phased out.
Can you elaborate on that, please? Because that's really important. When you say that, you know, you're such a big employer, then you sort of control the bargaining process, and workers don't have much recourse. Can you elaborate on that, or what that means?
Yeah, so there's been a fairly nascent attempt to apply the antitrust laws to labor markets. You know, the question is whether or not this consumer welfare standard that we talked about earlier is going to be flexible enough to pick up these harms. And so there's some really important cases coming down the pike. I'm involved in a few, so I have to be a bit careful about speaking of them. So I'll just talk in general. You can use the antitrust laws to go after exclusive contract. So these would be requirements that a worker, sign a long-term commitment to work for you and can't ever leave, or if they do leave, there's a cooling out period, or you have a right to match any outside offers. Those sorts of provisions are being challenged now under the antitrust laws. This is a relatively new thing. There are no poach agreements that are being challenged. The Attorney General of Washington entered into a settlement with a whole bunch of chains. You may be familiar with some of these. I don't want to mention names because I'm involved in some of these cases, but whereby the franchise agreed to terminate what was called a no poach policy. That is, they had gotten all of their franchisees together and agreed that no one would poach a worker from any of the firms that are inside of the family, even though they were competing for the same set of workers. So these sorts of restrictions have recently been challenged. We'll see if the courts recognize these as being antitrust violations. But back to Amazon, the concern here is simply that if you shrink the set of outside opportunities, say for an Amazon worker, where could an Amazon worker go? Is in a warehouse right now, if not Amazon, right? And if those outside options become so unattractive because they just don't exist, or because they're unsafe, for example, I read that Amazon is doing a good job in the sense that it's going to create testing for its own employees, but imagine how an upstart firm would ever kind of deploy the same technologies. Amazon apparently is spending hundreds of millions or billions of dollars on testing. And so now it's yet another dimension that kind of makes the playing field unlevel between Amazon and its rivals. And so in all those reasons, a worker at Amazon becomes very beholden to his or her job. And that's what emboldens Amazon and makes them feel that, oh, okay, we no longer have to pay the $2 per hour hazard fee that we did at the onset of the pandemic, because really, where are these people going to go, right?
Because you control everything.
Right.
But so more broadly, okay. Now I know let's try to understand this better and explain to our audience. Then we've got this phenomenon of big tech companies permitted or allowed or facilitated largely by technology, right? By technological innovation. Lo and behold, when the internet came along, what was that, in the late 80s, early 90s, if anybody could have predicted this kind of evolution, and the emergence of these giants and all that. And so we are on the other side here, and we are the consumers, right? And so what are we saying? Oh, this is a good thing. I have all these things. I can access Google. I can do my search. I can go online and buy my whatever stuff, whatever it is now, anything. You can buy an elephant probably on Amazon. I don't know. And isn't that nice? But on the other hand, somebody says, no, it's not nice, because these companies, and you're not even aware of it, by studying your habits, where you go, where you do, the kind of places where you go eat, your shopping habits, basically they control you, and they'll send you their information and promotions based on your established habits and all that. And so you are essentially a pawn in the hands of these, skillful, perhaps evil, manipulators, whose only concern is to make money from you, and you giving them all the information they need to, target, to kind of put you in a particular slot and know exactly the kinds of things you're likely to buy and how much and how often and all that. So this is really not good, because we're losing our cherished and constitutionally protected right to privacy. So where are we on this, really? Or is this just a big exaggeration? I mean, this is really
I think that
of a conspiracy theory. What is this?
No, I think that the abuses of privacy are real, but I don't think that they're so severe that they're going to lead some kind of consumer revolution that'll stop this. Remember, I mean, the consumer, and the first order of business for the consumer, I think, is, am I getting this product that I want? Am I getting it at the lowest price possible? And to respond to that question, the answer is yes. I mean, Amazon is doing its job. Google is getting you the results. So we're not going to, like I said, we're not going to be able to identify these short-run price or output effects that typically motivate, consumer injuries and motivate and animate, antitrust interventions. The harms, and that's why I don't think this is going to come from consumers, some kind of consumer revolt. The harms, as I like to keep going back to, is this notion that if you make the playing field so unlevel for the edge providers who are operating at the edge, whether it's the merchants on Amazon's ecosystem or content providers on Google's ecosystem, if you're going to make the playing field so unlevel that any good idea is appropriated by the platform, then eventually they're just going to throw in the towel, and in future periods we're going to get less choice and potentially higher prices. But you shouldn't expect consumers to kind of put on their future hats and say, oh, my future self is going to be very offended by this conduct, and so we better shut it down. That's just not how consumers think. So this is going to have to come, I think, from an act of Congress, and not consumer driven, but I think the constituency here are going to be independent merchants and independent content providers who feel like they're being run off, and that their small upstart companies have no chance of competing against the vertically integrated platform.
But then Amazon could say, hey, we're more efficient, and this is about economics, creative destruction, right? Capitalism. And so the more efficient producer or service provider prevails, and the others die, as it happened in history, in many, many different cases. Who says that a small entity, a small merchant, has the right to survive?
Yeah, I think that once the idea is conceived, you're absolutely right. If we set aside the incentive effects, right, that once the idea is conceived, that if Amazon can do it at a lower price, then yes, then there's no harm. In fact, there's arguably even a small benefit for consumers. But let me go back to the first point, which is once the idea is conceived, right, we believe, we have faith, and I can give you historical examples or regulatory examples, like in the content, in the programming space, that some of the best new ideas, right, we're talking about the conception of the ideas, come from independence and do not come from big, crusty, bureaucratic conglomerates, right? And so the idea is that Amazon and Google might be interfering with this creative process, right, in future periods, right? And so I want to give you one analogy that I think is very apt, which is that in 1992, Congress intervened to stop, tell me if this sounds familiar, appropriation by a vertically integrated platform, right, that was stealing ideas and then steering its customers to the clone, right? And these were vertically integrated cable operators who were kind of eyeing and picking off what was good content, good programming, right, making it their own, and then moving the independent who came up with the idea originally to some tier that almost no cable customers subscribe to, or would have to pay, $10 extra a month to get access to, right? Congress was watching this appropriation by the platform in the late 80s and then in the early 90s, and said, you know what? We think that independents are some of the best sources of innovation when it comes to coming up with original creative content. We want to make sure that the playing field is hospitable to independents, because independents are a great, not the only, but a great source of innovation. So we set about creating a set of protections that existed outside of antitrust. This is important, right? We didn't rely on the consumer welfare standard to protect independent programmers. We came up with a new set of protections, and we said that if you feel that you've been discriminated against by, say, Comcast, right, you can bring a discrimination complaint to the FCC and have your case heard. And if you can meet certain evidentiary criteria, right, we're going to stop Comcast from discriminating against you. And the result was that we had a proliferation of independent networks that just sprouted in the 90s and in the aughts, in part, I believe, because of these protections that Congress created. And there's nothing that would stop Congress from creating the same sort of protections today for independent merchants who are competing on the Amazon ecosystem, or independent content providers who are competing, or trying to compete at least, in Google's ecosystem.
I mean, I fully agree that the beauty, if you wish, the secret sauce of America is the ability to foster and produce innovation, and thank God for that. But it seems also, beyond what you were saying, please tell me what you're thinking about this. What we have seen on the part of big tech is that when they see a new, promising upstart coming up with the products or services or something, or modification or something that's really interesting and catchy, what do? They go out and buy it. Okay, maybe for an exorbitantly high amount of money that the shareholders of the potential target, rarely say, oh, no, we really want to stay independent, we want to continue this. They'll take the money and run. And so the big tech has just gobbled. It's has not killed the competition, but has eaten it up and made its own. Now, and again, that may actually, I'm going to say, diminish in the long run the innovative value of whatever was going on in that firm when it was independent, because now it's part of the empire, right? And yes, maybe some of the same people are still there, but they don't have the same latitude because they are, underlings in a bigger corporation. What can we do about this, or is that an impossible proposition? I mean, can we? This is really not about antitrust, I don't think, unless we could argue that the company is buying everything and therefore becoming a trust and becoming a monopoly. But how do you view this? Is that a real problem, or is this a problem with no solution?
No, it's a problem. And one thing that you left out of your story, it's really important, is, and we have great anecdotes about this, is that yes, Facebook, for example, paid a lot of money to take out, app providers that kind of offer neat complementary services to the basic Facebook functionality. But Facebook also was hiring teams of engineers to appropriate app functionality, right? And just make it part of their own. And they would approach a target and say, look, we can either copy what you're doing, right, and basically wipe you off the face of the earth today, or we could buy you. So just recognize that whenever you hear about those stories where a company sells out to Facebook, it always wasn't a happy ending, in the sense that they sometimes had a gun to their head.
That's a good point.
Right, but there are things that antitrust can do on this front, but not under the current law. So one proposal that is being floated about is the notion that we would create a presumption that anytime a dominant tech platform were to buy a company, and we're starting to read about more and more examples. I think Facebook had something in the news today about buying a new company for $400 million. We create a presumption that any acquisition by a dominant tech platform would generate anti-competitive effects, and the burden of proof would be on the platform to prove otherwise. See, right now, the burden of proof falls on the antitrust agency, and they've got to go in front of a court, right, and try to come up with an argument with an economist and prove that if Facebook or Amazon or Google buys some upstart, that's going to generate anti-competitive effects, and that's very, very difficult, right? And so, of course, these companies have exploited that lax standard and have gone on a buying spree and just bought up hundreds of independents throughout the ecosystem. So you're never going to be able to stop that under the current standard. If you want to stop it, you'd have to change the standard. And so there's some very important people that putting out ideas. And I should also note that there's the House Antitrust Subcommittee has been soliciting comments about how to reform our competition laws, not just within antitrust, but also outside of antitrust. I filed comments in that proceeding, and many other antitrust scholars have as well. And be on the lookout for a report from that committee. It's headed up by Representative Cicilline, to offer up a set of legislative proposals that would try to fill the gap in protection that we have right now from kind of an outdated and outmoded antitrust law.
Indeed. Well, yes, it seems, again, please correct me if I'm wrong, but our legislation, as I said, goes back at least 100 years, in fact, more than 100 years. The Sherman Act and subsequent legislation and creation of the Antitrust Division and the Federal Trade Commission and all that. But it's the stuff, lawyers are not technology experts, right? They're not, and nobody could have figured out 100 years ago the pace of innovation, changes in market dynamics, and therefore try to assess and establish the possible economic ripple effects of this or that or the other. What you were saying a moment ago sounds very attractive. that it should be incumbent upon the buyer to say that no harm will be done. And you have to make a convincing case, as opposed to the other side say, yes, there will be harm and it's going to be this and that, because it's in the future, right? The harm. It's not today. So how do you assess it? How do you measure it, and all that? So
can I interject? George put a question in here, and I would be
please, absolutely,
remiss if I ignored him. George has my favorite cafe in the entire world, Cafe Chocolat, which I miss dearly because I'm not going downtown any longer. But he asked, how do we make sure that when we take action to curb some organizations from getting too big, we're not using broad strokes that hurt the ability of organizations at every level to grow? It's a good question. And it's actually an argument that you hear the platforms making a lot, which is that, if you intervene, you're not only going to curb our behavior, but you might also curb the behavior of smaller firms. And so that is not true, at least under antitrust laws. Remember, a court cannot find an anti-competitive violation unless there's a combination of both market power and a restraint that generates anti-competitive effects, right? And so if what this does is it largely immunizes small firms without market power from antitrust scrutiny. In other words, a large firm might run afoul of the antitrust laws by imposing, say, an exclusive dealing restriction on its customers. And that's only because it is in a position to inflict harms. Whereas a small firm might copy the same strategy, but because it doesn't have, say, a large presence in any relevant market, it will largely evade antitrust scrutiny. So I would, my response to George and others who are worried about that antitrust might kind of trip up smaller actors in the economy, I'd say don't really fear that, because an evidentiary requirement just to get past first base in an antitrust lawsuit is a demonstration that the defendant have market power. And so if you don't have market power in any relevant market, you can get away with a lot of things that a large monopolist cannot get away with.
We're getting close to the end of our allotted time, but I wanted to go back for a moment to how sort of the global regulatory environment, which I know obviously it's a difficult question, but we, following the American example, right, which goes back more than 100 years, then regulations and attempts to protect markets were introduced in different countries. In Europe, there is a competition commissioner at the European Union. There is antitrust law in Japan, in Korea, to name, of course, Canada, Mexico, and China, of course, as well, although it's came into being very recently. And the question is, in a global economy as we have it now, with global players, especially the tech companies, is it even thinkable to consider better harmonization of different statutes and different judicial philosophies when it comes to enforcing or trying to guarantee fair competition in markets? I mean, we know, at least superficially, that if we look at Japan, the Japanese economy and the South Korean economy are very different from ours. In keiretsu and chaebol and all, in other words, they were born with collusion of these economies grew with the idea of big companies cooperating, and some others would say conspiring, to do things together. And then it was only very recently that they said, well, maybe there's too much of it. Maybe we should tone it down and not consider it fair game that all this is going on. And then you have China. Of course, now with China, we've got another set of issues, much more complicated than that has promoted its state-owned corporations, right? It's giants that dominate domestically certain fields, but are huge enough to become real players internationally. Of course, the case of Huawei, somebody was, I think was one of the questions alluded to this, is, has been all over the place, the headlines, etc. There, it's not so much an issue of antitrust, but an issue of being perceived, at least by some, rightly or wrongly, as an arm of the state. and therefore becoming at the same time a business, an intelligence gathering operation, and an influence peddler, and what have you. At the same time providing, top of the line technology. So how do we reconcile all this? Of course, we have a domestic environment which is controlled by, by US laws, but we're part of this global economy with so many other different players. Do you see that having even a remote hope of being addressed, or is it just too complicated to harmonize so many different?
Let me give you two quick reactions. I mean, there's a great book to commend everyone to read, Thomas Philippon, about looking at differences in the EU versus the US approach. And one of the ideas, one of the kind of the brilliant ideas of designing the EU system is that it took away power from local countries, regulatory authorities who were previously captured by the incumbent monopolies, right? And he thinks that that's a huge reason for why you have so little enforcement here in the United States compared to Europe, and that the EC isn't captured in the way that the Department of Justice or the Federal Trade Commission can become captured by a large incumbent monopolist here. That's kind of so that's a benefit of kind of a harmonization where you subscribe to a larger system. But having said that, I don't think there's any way that we're ever going to convince Americans that we should be subject to European rules, right? But that isn't necessary. What I think is going to happen is that we're going to observe how the difference in standards between the EU and the US play out in terms of various metrics, right? Concentration, price cost margins, labor share, like on all these dimensions, Europe is beating us, right? And I think that eventually we'll start to say, you know what, maybe we should just take a look at their standards. We don't have to necessarily harmonize with them, right? But if their standards are producing better outcomes, right, with respect to workers, for example, their workers getting a higher labor share than our workers, or their consumers paying a lower price cost markup than our consumers, right? We might just look at them and say, maybe something is up with these difference in standards. Maybe the standard in the United States, the competition standards have become so exacting so as to become a dead letter, and we should emulate what the Europeans are doing. They've got an abuse of dominance standard. We do not. The burdens, the evidentiary burdens are different. Here, the plaintiff or the agency has to prove a harm, whereas there, the EC finds a harm, and then it's incumbent on the respondent to disprove it, in a court of appeals. So there's some really important differences, and I would say rather than us being forced to subscribe, we should just kind of keep an open mind on these differences and how these differences are playing out, and it might make sense to reconsider our standards so as to achieve some of the desirable outcomes that they are achieving across the pond.
I mean, again, if not to go too much into fantasy land, we're still dealing with this coronavirus pandemic, but if one day the idea that at least it's on the table somewhere of a free market agreement, right, between the United States and the European Union, should that come to life at some point in the future, hopefully in our lifetimes, well, then this issue becomes more relevant. Because if the two economies of what are, after all, the two biggest pieces of the West, North America, and Europe, if they come together, then you would think it would make sense to have a regulatory environment that is shared, right, and mutually recognized on both sides of the Atlantic. And so these ideas, as you were suggesting, of at least looking seriously at different standards and different approaches is not so fantastic as it might have been 30 years ago when the US was the only big economic power. Everybody else was too small to be even sitting at the table, and now it's different. So who knows? Well, so I guess we have to wrap it up now, but I really want to thank you so much, Hal, for illuminating these areas that for most of us are a bit mysterious. And in particular, trying to explain how we as consumers are happy in some ways, but at the same time captive without maybe being really fully aware of it, of this big tech companies that have been created by American ingenuity, but where things have evolved in a way that maybe was not exactly as planned. Any last comments for you, please?
Well, just that I really appreciate you having me on the show, and I'm excited about seeing it once it's posted. And keep me in mind if you ever have any other problems in the space.
All right. So once again, many thanks to your kind collaboration. Thanks to our audience of being sorry about the incidents that Denise mentioned before, but we appreciate your active participation and interest. And we'll see you soon for another edition of our events. Our next event will be on energy with Lupo Iaresi, and that will be on Monday. And then we will have another one moderated by our good friend Mark Meyerowitz, and they will be on next Thursday, I believe. And that will be about how international organizations are coping with the present crisis. So with that, thanks to all of you. Thanks to Denise for kindly putting all this together. Thanks to you, Hal, again. We'll talk soon. Bye-bye.
Thanks. All right. Bye-bye.